Hey guys, welcome back to the channel where I cover missing persons, unsolved cases, crime news, and more. Well, as of Friday, Sarah Boone is representing herself. She is going to be her own attorney, which, while she claimed all this time she didn't want to represent herself, well, I think she kind of does. So let me go through the order. It's about a 15 pages, I believe, the Judge Kranick put out on Friday. All right, yeah, he filed this was filed through the court system on 6/28, 2:47 p.m. So it was kind of the end of the day. I'm not exactly sure what time of the day they met, but doesn't matter. It was Friday. Here is the order. This cause came before the court on June 28, 2024 on defense counsel Patricia A. Cashman's Esquire motion to withdraw as counsel filed June 11th, 2024. The court, having reviewed the motion, having reviewed the court file, having reviewed the audio transcripts from various hearings, having considered the positions offered by counsel Patricia A. Cashman Esquire, having considered the testimony offered by defendant Sarah Boone, and having considered the positions offered by counsel for state, hereby finds charges. A. On March 23, 2020, by way of information, the defendant was charged with second-degree murder. Procedural history. B. On February 26, 2020, the Office of the Public Defender, 9th Judicial Circuit, in and for Orange County, Florida, the public defender and attorney number 1 was appointed to represent defendant. C. On March 9th, 2020, the public defender moved to withdraw due to defendant retaining private counsel, to wit, Marcio Padilla, Esquire, and the Padilla Law Group. D. On March 11th, 2020, that certain order allowing withdrawal was entered, which withdrew the public defender from further representation of the defendant. E. On April 18, 2022, Padilla moved to withdraw due to irreconcilable differences arising between undersigned and the defendant that have made it impossible for undersigned to effectively represent his client. As always, it is difficult to convey all particulars to the court and at the same time maintain all duties to the client, unquote. This motion was served upon the defendant, and the defendant confirmed receipt. See letter dated April 20th, 2022, and filed on April 26, 2022. F. On April 29th, 2022, a hearing was held on Padilla's motion to withdraw. At the time of this hearing, Padilla had been representing the defendant for 2 years. Defendant was present for the hearing and was sworn. The court advised Padilla that the court had received a letter from the defendant, a letter dated April 20th, 2022, and filed on April 26, 2022, which seemingly objected to Padilla's withdrawal. The court advised Padilla that the options were to not proceed on Padilla's motion to withdraw or provide the court more about the, quote, irreconcilable differences, unquote. Padilla requested an opportunity to amend the motion to address the, quote, irreconcilable differences, unquote. The court reserved ruling on Padilla's motion to withdraw, gave Padilla until May 3rd, 2022, to prepare and file an amended motion with a hearing to be heard on the week of May 9th, 2022. The state advised of Padilla's diligence and preparation, and the court commended Padilla's work. Defendant testified to, quote, lack of trust, unquote, between herself and Padilla. That seems to be a common theme with Sarah Boone. G. On May 4th, 2022, Padilla filed an amended motion to withdraw, which supplemented original grounds. I. Undersigned's relationship with defendant has become adversarial. The aforementioned adversarial relationship has interfered with undersigned counsel's ability to effectively represent his client, essentially preparing for trial. 2. Undersigned appreciates the court providing him the opportunity to amend his previously filed motion to withdraw. However, After further researching the issue, undersigned is still under the belief that the specifics of the adversarial relationship may disclose information that may prejudice his client, and such as will stand mute on the specifics. So it sounds like they were having issues, but he didn't want to be specific due to respect for himself and the client, which is commendable, you know. H. On May 6, 2022, Padilla filed a second amended motion to withdraw, which further supplemented the original grounds. Undersigned relationship with the defendant has deteriorated to a point where undersigned counsel can no longer give effective aid in the fair representation of Ms. Boone's defense. This motion is in compliance with Florida R. Judge Admin 2.505F1 and Rule 4-1.16b. Rules regulating the Florida bar are present, or whether the attorney-client relation has deteriorated to a point where the counsel can no longer give effective aid in their fair presentation of a defense. See Sanborn 475, so 2D at 314. I. On May 10, 2022, a hearing was held on Padilla's second amended motion to withdraw. Defendant was present for the hearing and was sworn. Padilla advised the court that he had no other choice to file the motion due to ethical concerns. Defendant confirmed that she wanted to terminate Padilla as her attorney. The state expressed concern of a strategy to allow defense attorney after attorney to represent defendant. The court advised defendant of the state's concern regarding a strategy of defendant being unhappy with every attorney, and advised defendant about the dangers of self-representation. The court appointed the public defender. This is attorney number 3. So this is 2022, May 2022. Okay, and where she says she's not fired any attorney, well, right here it states that she confirmed she wanted to terminate Padilla. So yeah, I think that's an untruth there, Sarah, in your letter. And also, this is the point when the court was telling her you're already having issues with these attorneys, and they're telling her to be wary. And again, this is May 2022. J. On June 6, 2022, the public defender moved to withdraw due to a conflict. That one was quick. K. On June 7, 2022, that certain order allowing public defender withdrawal was entered, withdrew the public defender from further representation of the defendant and appointed the Office of Criminal Conflict and Civil Regional Counsel, RCC, and attorney number 4. All right, we're in June 2022, attorney number 4. Attorney number 3 just was there barely at all for anything, it looks like. L. On June 10, 2022, RCC moved to withdraw due to a conflict. M. On June 22, 2022, that certain order allowing the Office of Criminal Conflict and Civil Regional Counsel withdrawal was entered, which withdrew RCC from further representation of the defendant and appointed Mark Consuelo and attorney number 5. That is how quick she went from 2 to 5. 3, 4, 5. 3 attorneys since she dropped Padilla in May of 2022. They were dropping like flies already. And on July 8th, 2022, the Consuelo moved to withdraw due to conflict, and he's gone. Oh, on July 11th, 2022, that certain withdrawal order was entered, which withdrew Consuelo from further representation of the defendant and appointed Frank J. Bankowitz. This was attorney number 6. P. On July 12, 2022, Bankowitz in open court requested a continuance due to his recent appointment, and same was granted. Thereafter, the court set a pretrial conference for October 25th, 2022 at 9 a.m. and trial during the period beginning November 7th, 2022. Q. On October 25th, 2022, the court held the pretrial conference and addressed the court's understanding that a continuance was being sought, and the court's judicial assistant was to reach out to the parties to confirm if a continuance was being sought. R. On October 27th, 2022, Bankowitz filed defendant's motion to continue. S. On October 28, 2022, the court entered that certain amended order on defendant's stipulated motion to continue, which set a pretrial conference for January 17, 2023 at 9 a.m. and trial during the period beginning January 30th, 2023. T. On November 22nd, 2022, the court set a status hearing on Tuesday, December 20th, 2022 at 10:45 a.m. U. On December 19th, 2022, Bankowitz moved to withdraw due to, quote, the irreconcilable differences which have arisen between the undersigned, his client, his family. The undersigned will be unable to efficiently and properly continue representing the defendant herein. There's a pattern that we've all noticed, and it continues. Irreconcilable differences. She can't work with lawyers. V. On December 20th, 2022, the status hearing was held. Bankowitz did not appear due to a car accident, and the court reset the status hearing for December 22nd, 2022 at 11 a.m. W. On December 22nd, 2022, the reset status hearing was held. Bankowitz appeared virtually, and due to technical issues, Bankowitz was unable to hear the court. The court reset the status hearing for December 27th, 2022. X. On December 27, 2022, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. The court advised defendant the court had received letters from the defendant, a letter dated October 3rd, 2022 and filed on October 7th, as well as a letter dated November 3rd, 2022 and filed on November 7th, 2022, and a letter dated December 5th, 2022 and filed on December 14th. 2022. The court conducted a Nelson hearing, and the defendant was not seeking to remove Bankowitz. Bankowitz advised the court of the 1,000s of pages in discovery that he had reviewed and organized in his contact and potential use of collaboration with expert witnesses, including experts that Padella, attorney number 2, utilized. Bankowitz advised the court of the defendant's attempts to call Bankowitz at a rate of 5 to 10 times a day. Yeah, she's a little excessive, as we know. Bankowitz further advised of his efforts to balance the demands of other clients with the defendant's expectations for communications. In response, defendant reposted that Bankowitz's representations were untruths, raised Bankowitz's prior public reprimands for lack of communication, alleged Bankowitz's action in this case rose to a similar level, and then sought to remove Bankowitz. Again, she wants him gone. I don't ever fire my attorneys. All right, Sarah. The court pointed out defendant's inconsistent statements within minutes of them being made and addressed concerns over defendant's motivations, especially when there is something defendant disagreed with. Bingo! The court specifically advised defendant that she is not entitled to endless line of court-appointed lawyers until you find the right one that you personally prefer. Well, she just found that out on Friday, huh? The court also explained the circumstances where defendant could represent herself. Ultimately, defendant did not request to remove Bankowitz. The court denied Bankowitz's motion to withdraw and directed Bankowitz to have a conference with defendant prior to the pretrial conference previously set for January 17, 2023. Yeah, I honestly felt a little bad for Bankowitz. I did. Why? The case was continued several times due to Bankowitz's attempts to retain an expert through JAC and JAC's response to same. Z. During this time period, the court had received several letters from defendant. A letter dated January 10th, 2023 and filed on January 17th, 2023. A letter dated March 22nd, 2023 and filed on April 14th, 2023. A letter dated April 6th, 2023 and filed on April 14th, 2023. A letter dated May 15th, 2023 and filed on May 18th, 2023. A letter dated June 29th, 2023 and filed on July 21st, 2023, and a letter dated August 2nd, 2023 and filed on August 7th, 2023. AA. On August 22nd, 2022, Bankowitz again moved to withdraw due to irreconcilable difference arising between undersigned and the defendant that had made it impossible for undersigned to effectively represent his client. As always, it's difficult to convey all particulars to the court and at the same time maintain all duties to the client. The defendant will not be satisfied with any attorney unless said attorney does not have a caseload and can dedicate his or her time solely to Mrs. Boone's case. Another right on the money comment right there from Bankowitz. The best possible avenue is to have the defendant represent herself, as no attorney can satisfy her. Telling you what, every attorney she's had, this is exactly what they think. BB. On September 8th, 2023, a hearing was held on Bankowitz's motion to withdraw. Defendant was present for the hearing and was sworn. Bankowitz addressed defendant's derogatory statements, i.e. dud, buffoon, and berating behavior. Sort of sounds like how she was treating Cashman, right? The court advised defendant that the court had received letters from the defendant, a letter dated August 26, 2023, and filed on September 7, 2023, and a letter dated August 30th, 2023, and filed on September 7th, 2023. After the court's colloquy of defendant and her acquiescence to Bankowitz's withdrawal, the court granted Bankowitz's motion to withdraw and appointed Winston Hobson, attorney number 7. Therefore, the court sets a status conference for October 30th, 2023 at 10 a.m., set a pretrial conference for November 28th, 2023 at 9 a.m. After setting these dates, the court pointed out the deterioration of the working relationship between defendant and Bankowitz. The court further cautioned that if this becomes a problem on either court-appointed attorney, I'm going to look more closely at what the alleged disputes are. The court further advised that there are certain decisions the attorney gets to make and certain decisions a defendant gets to make, i.e. go to trial and or testify. The court cautioned as to the defendant's unrealistic expectations regarding court-appointed counsel and reminded defendant of her right to retain private counsel. CC. On October 30th, 2023, the status conference was held. Hobson advised as to his conversations with defendant in setting a status in January 2024. Therefore, the court set a pretrial conference status as to readiness for trial for January 16, 2024 at 9 a.m. and trial during that trial period beginning January 29th, 2024. Remember, we thought, oh, it's getting a little better. And yeah. DD. On January 12, 2024, Hobson filed that certain motion to continue waiver of presence and requested a 3-docket continuance. EE. On January 16, 2024, the court addressed Hobson's motion to continue, granted same, set a pretrial conference for May 3, 2024 at 9 a.m. and trial during the trial period beginning May 13, 2024. FF. On February 1st, 2024, Hobson moved to withdraw due to irreconcilable differences, including but not limited to ethical considerations. GG. On February 9, 2024, a hearing was held on Hobson's motion to withdraw. Hobson addressed a number of issues as for the basis for withdrawing, including disagreements on legal strategy, of what can and cannot be done, a lack of resources, and defendant's demands make her difficult to work with, including defendant taking non-viable legal positions and being unreasonable. Boone unreasonable? No way. As to a key substantive defense, Hobson advised that the retained and undisclosed expert is not keeping with what the defendant has in mind. The court advised defendant that the court had received a letter from defendant, a letter dated January 19, 2024. The court outlined the overriding claims for withdrawal by Padella, Bankowitz and Hobson, adversarial relationships, lack of satisfaction, and inability to meet defendant's desires. The court found that all of defendant's relationships with all court-appointed counsel have deteriorated, such as defendant and the court-appointed counsel cannot work together. The court advised defendant that although defendant has a right to court-appointed counsel, that right is not unlimited. The court twice advised defendant that defendant may not be provided another court-appointed attorney, and defendant would have to represent herself if circumstances similar to Hobson's motion to withdraw occur. So they are giving her many, many warnings and going, hey, we're getting to the end of the line here, lady. The court further advised defendant about the dangers of self-representation due to defendant's lack of legal training and knowledge. Defendant never stated that she did not understand that she may not be provided another court-appointed attorney. The court granted Hobson's motion to withdraw and appointed Patricia A. Cashman, attorney number 8. The court is aware of Cashman's extensive experience representing criminal defendants as both an assistant public defender and in private practice, including representing defendants accused of murder, and is widely known to be able and willing to deal with and manage difficult clients. The court set a status hearing for April 12th, 2024. And I'll say this again, Cashman was her best chance, and she has blown it. HH. On April 12, 2024, the status hearing was held. Cashman advised as to depositions that had been set, the hiring of an expert, and a request for a future status date to address a trial date. The court set a status hearing for June 7, 2024. II. On June 7, 2024, the status hearing was held. Cashman addressed her dates of availability for trial. Defendant was present for the hearing and was sworn. Therefore, defendant advised the court to walking out of multiple meetings with Cashman, which was confirmed by Cashman utilizing a pretend judge to oversee defendant and Cashman, launching multiple attacks on Cashman's professionalism, and providing the court with letters dated June 4th, 2024 and June 7th, 2024, and both of which were filed on June 21st of 2024. Cashman advised to her efforts and time spent on the case so far, 20 hours. Cashman advised disagreements on legal strategy, including defendant attaching importance to issues that may not legally be important. And represent, defendant accused Cashman of lies and half-truths. JJ. On June 11th, 2024, Cashman moved to withdraw under Florida rule regulating the Florida Bar 4-1.7b2. Subsequential risk that the representation of one or more clients would be materially limited by the lawyer's responsibilities, to another client, and irreconcilable differences, including but not limited to ethical considerations, have arisen, such as counsel can no longer provide representation. She should have that one memorized by now. KK. On June 28, 2024, a hearing was held on Cashman's motion to withdraw. Cashman relied on Florida rule regulating the Florida Bar, and basis for her withdrawal. LL. At no time has defendant refused to accept the services of any of her 7 appointed attorneys. Law. MM. Both the United States and the Florida Constitutions guarantee an indigent criminal defendant the right to assistance of appointed counsel. See U.S. Constitution Amendment, and it lists all that information if anybody wants to look it up. And the counsel clause of the Florida Constitution under Article I, Section 6T, recognizes the right to counsel as well as self-representation in all criminal prosecutions. Forfeiture of right to counsel. OO. A defendant in a criminal case can forfeit a right to court-appointed counsel. PP. A forfeiture is an extreme measure that flows from defendant's abuse or manipulation of the right to counsel and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. Forfeiture is a judicial response that adapts the course of the legal proceedings to the defendant's choice to engage in misconduct that undermines the legitimate exercise of the right to counsel. QQ. As set forth above, defendant's recalculation, I am saying that completely wrong, guys, sorry, to the attorneys who were not conflicted out, Padilla, Bankowitz, Hobson, and Cashman, antagonism, hostility, and attacks on the professionalism of Padilla, notably over a year after the fact, see footnote 9 above, of Bankowitz and of Cashman, and personal attacks on Padilla, Bankowitz, and Cashman. Each of these attorneys were required to withdraw. So they're like, listen, you can't work with people. You're insulting. You can't do that. RR. It has become apparent to the court the defendant will not permit herself to be represented by anyone. SS. Additionally, the withdrawal of 8 different attorneys, 7 of which were court appointed, leads to the determination that the defendant has forfeited his right to counsel. TT. Under Florida law, the facts at bar amount to binding forfeiture of the right to counsel. UU. As the court finds defendant has forfeited the right to court-appointed counsel under Florida law, there is no obligation to conduct a Ferretta hearing or to otherwise warn a defendant of the dangers of proceeding pro se. Waiver by conduct. VV. The court can find a waiver by conduct to the right to counsel. A waiver by conduct requires the defendant to be warned about the consequences of his conduct, including the risks of proceeding pro se. WW. On February 9th, 2024, defendant was twice advised that another court-appointed attorney may not be provided. XX. On May 10th, 2022, defendant was advised about the dangers of self-representation. YY. On February 9th, 2024, defendant was advised about the dangers of self-representation. ZZ. As of February 9th, 2024, the instant case had been continued 16 times. AAA. As of June 26, 2024, this case has been pending 4 years, 3 months, 5 days from the date of the filing the information on March 23rd, 2020. BBB. Actions speak louder than words. Although defendant's words seemingly reveal a desire to go to trial, however, as set forth herein, her actions and inability to work with court-appointed counsel are repeated over and over, allowing defendant to her 8th court-appointed attorney, which would be her 9th overall attorney, would only serve to delay the case further and encourage defendant to persist in efforts to prevent the resolution of the case on its own merits, the concept of which was first brought defendant's attention on May 10, 2022. Defendant complains that Bankowitz and Hobson, 2 court-appointed attorneys, failed to meet and communicate when the defendant is provided court-appointed counsel who will meet and communicate. Cashman, the ways and means of meeting and communicating are unacceptable to defendant. She gets upset that those 2 won't meet with her, and then when Cashman does, even if it is via Zoom, she's not happy. She's not happy one way or the other. CCC. Under Florida law, the facts at bar amount to binding waiver of the right to counsel. Orders and adjuds as follows. 1. Cashman's motion to withdraw as counsel filed June 11, 2024 is granted. And I know she was so happy about that. 2. As a condition of Cashman's withdrawal, Cashman shall provide the court an order for costs to obtain transcripts of depositions for the 2 witnesses Cashman deposed. Upon completion of the transcription of the depositions transcripts shall be sent directly to defendant Sarah Boone by Cashman at the Orange County Jail. Therefore, Cashman shall file a notice with the court reflecting that the deposition transcripts were provided to defendant Sarah Boone, and such notice shall include the date sent and address of the defendant Sarah Boone. 3. Defendant Sarah Boone has forfeited her right to court-appointed counsel. 4. Alternatively, defendant Sarah Boone has waived her conduct, her right to court-appointed counsel. 5. The trial management conference shall remain specifically set for Tuesday, September 24th, 2024 at 1:30 p.m. 6. This case shall remain specifically set for trial for the 2-week period beginning Monday, October 7th, 2024, and will not be continued for any reason except by extraordinarily good cause, and such extraordinarily good cause shall not include retention of counsel by the defendant. 7. Any and all pretrial motions in this case must be filed no later than the close of business on Monday, July 22nd, 2024, done and ordered by Judge Michael Kranick. And mic drop. I'm pretty sure that's how he felt when he wrote that. So, she is now attorney, well, her own attorney anyway. She's attorney Sarah Boone. Which, whether she said it or not, I think she wants it that way. it's gonna be a it's gonna be an interesting trial, and that's putting it mildly. And for those wondering about her whole, remember she was asking that she had fans, and supposedly they would pay for her bond. Well, not so much bond, but apparently she does have one fan, and this one fan has set up a GoFundMe to help Sarah with legal costs. Yeah. This one person, I guess, is Sarah's number one fan. So, I guess she's got one. I'm sure she's got others, But I wish her the best of luck. At this point, we need to get this show on the road, Sarah. And I know I plan on being there October 7th. I'm going to set my PTO because it's time to get this one going. And one more thing I will be looking up, I'm going to see if I can find out, is I would like to know how much her case, I'm not talking about her being in jail, I'm talking about all these attorneys that we have appointed by the state and all the experts and what have you. I want to find out how much money the taxpayers have paid for Sarah Boone's defense. So I'm going to file that this week. I need to figure out where to file that to. Ask probably the court clerk, but I'm not sure. But yep, I'm I don't know. I think this was really the only way Judge Cranick could handle things. But so what do you guys think? I know everybody who's been following this case is just like me. We're ready to have it sit in front of a jury. And she's been delaying the inevitable, and I don't know why she thinks she's going to be successful in her case. She, again, as far as I'm concerned, she screwed herself really bad by pissing off Patricia Cashman, because I believe she was her best hope. I really, really do. And I think she's going to regret it, whether she wants to admit to it or not. But again, let me know you guys' thoughts in the comments, and I'll keep you apprised of what quote-unquote Attorney Boone is up to. Keep an eye on her filings. But in the meanwhile, I hope you guys have a great rest of the day. And most of all, stay safe.